in approaching your decision and judgment. In this context, the court has heard today from my senior, AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the Commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the, even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IBC. The verification has to be done by the IBC. The declaration decision has to be made by the IBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong? Is it the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so, the coup was all right. And so, my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But it is a very dangerous thing, not only historically, but because Professor Kindiki revealed, perhaps unknowingly, that we now know that the doctrine of necessity has been discussed in their private thinking and now is brought here publicly. And when there is, next time, there doesn't have to be a chair and 3 people and 2 policemen clearing the chaos. Next time, when there is a manufactured group assaulting another group of 50, 100, 200 people, who will get up and say, we have taken power as an act of necessity? because our attempt to do so at Bomas to establish a new government not in compliance with the Constitution failed, as it should fail. But now, with the doctrine of necessity, we are there. And we will take on anybody who says that we are doing anything wrong, because the doctrine of necessity requires that we restore peace and order and move on. And then when we bring the matter to court, learned Professor Kindiki will be here to say, I will now refer to the case of Mandus Butiro, South Rhodesian law reports, and say, here it is. Here is Pakistan. Here is the case from Uganda after the Uganda coup, applying the same thing. And we say, this is the prophecy that is put forward now in their thinking, shown unwittingly, I think, by Professor Kindiki, and placed before the people of Kenya. We say, not only reject it, but reject it consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that again from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court, and he said, let us get at the substantive truth. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chabukati used, was illegal, because in the Gazette notice he lied and put forward just half of what the power he has needs to meet. And so, when we put these forward, they could not reply, but those who attempted the reply said, but look at this. This is his power, this is his this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment of the Regulation 67, by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the IBC Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office, and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened. What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government. Finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the respondents' counsel or supporters or by any reference to instructions that these values we kept in mind. This is how we advance. By postponing Kakamega, this is the value we advanced. By not checking the wrong printing of the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to